You're listening to the Bare Metal Cyber Prepcast, created to help you succeed in your educational journey. Learn more at baremetalcyber.com, where additional prepcasts, books, and training materials await. Let's get started. The California Delete Act expands the state's privacy landscape by directly targeting the data broker industry. A data broker is defined as a business that knowingly collects and sells personal information of consumers with whom it has no direct relationship. This distinction is important. Unlike service providers or contractors who process data on behalf of a business under contract, brokers aggregate information from multiple sources and resell it, often without the knowledge of the individual. For example, a consumer may never interact with a broker directly, yet their shopping history, geolocation signals, and online behavior may be compiled and offered for sale to advertisers. By drawing this line, the Act highlights the risks created by entities operating in the shadows of the data economy. Learners should see brokers as different from service providers. Brokers build businesses around data trading, while providers work under contract-bound restrictions. Under the Delete Act, data brokers must register annually with the designated state authority, creating a publicly visible registry. This registry serves two purposes. It provides transparency by identifying who is in the broker ecosystem, and it establishes accountability by giving regulators and consumers a reference point for oversight. Imagine a directory listing hundreds of data brokers, including their contact details and compliance status. Consumers can see which companies are required to process deletion requests, while regulators can monitor registration compliance. This registry approach reflects a broader privacy strategy, shine light on hidden actors and create formal structures to hold them responsible. For learners, registration embodies the principle that operating invisibly in the data economy is no longer acceptable. The Delete Act introduces a centralized deletion request mechanism, making it easier for consumers to exercise their rights. Instead of contacting dozens or even hundreds of brokers individually, a California resident can submit a single request through the centralized system. This triggers deletion duties across all registered brokers. Eligibility is tied to residency and identity verification, ensuring that only legitimate consumers can make requests. For example, a person who has never interacted with a broker can still demand deletion of their compiled profiles. Learners should recognize the significance. The centralized approach reduces friction, transforming what was once an impossible administrative task into a practical tool for reclaiming privacy. Verification requirements are critical to ensure the system cannot be abused. Brokers must implement secure identity-proofing processes that balance accuracy with accessibility. For example, a consumer may be asked to provide limited documentation or use a secure verification service before bulk deletions occur. This prevents adversaries from submitting fraudulent requests to delete someone else's data. At the same time, verification cannot be so onerous that it discourages legitimate users. The Act pushes for proportionality strong enough to block abuse, but not so burdensome that it undermines rights. Learners should see identity proofing as a trust mechanism. Without it, the system risks collapse under fraud. With it, deletion becomes reliable and sustainable. The scope of deletion under the Act is broad. It requires brokers to delete not only raw information they have collected, but also profiles derived or inferred from that data. For example, if a broker infers that a consumer is interested in luxury goods or belongs to a certain demographic, those inferences must also be erased. This ensures deletion is meaningful rather than symbolic. Learners should think of deletion as pulling up weeds by the roots. It is not enough to cut the surface data. The derived and inferred attributes must also be purged to prevent regrowth in the form of continuing profiles and marketing lists. The law also establishes an ongoing duty to delete future acquisitions after a consumer has submitted a verified request. This means deletion is not a one-time event but a continuing obligation. For example, if a consumer opts out in 2024 and the broker purchases a new dataset in 2025 that includes the consumer's information, that data must be deleted automatically without requiring another request. This approach acknowledges the cyclical nature of data trading and ensures that consumer choices endure. For learners, this provision illustrates the durability of privacy rights under the Act. Once asserted, rights follow the individual across time and transactions. Certain exemptions apply to deletion, reflecting practical realities. Brokers may retain information under legal holds to investigate security incidents or where statutory retention requirements exist. For example, data tied to fraud prevention investigations may need to be preserved temporarily. These exemptions ensure privacy rights do not undermine legal obligations or security needs. However, the Act requires brokers to document and justify these exemptions, preventing abuse. Learners should see exemptions as narrow carve-outs rather than broad loopholes. They exist to balance privacy with other legitimate obligations but are tightly bounded to avoid undermining the law's spirit. Response timelines and confirmation practices are also clearly defined. Brokers must act within specified periods to honor deletion requests and provide confirmation to consumers or to the centralized authority that requests have been completed. Status reporting creates transparency and accountability, allowing oversight bodies to track compliance across the industry. For example, if a broker delays or fails to confirm deletion, the state can flag it for investigation. Learners should view these timelines as procedural fairness. Consumers deserve not only rights but also timely execution of those rights, ensuring promises translate into practice. Record-keeping obligations require brokers to maintain detailed logs of requests, decisions, and technical execution. These records demonstrate compliance during audits or investigations and provide evidence in case of disputes. For instance, a broker may need to show when a deletion request was received, how identity was verified, and which systems were updated. Without such records, compliance becomes impossible to prove. Learners should think of record-keeping as the ledger of accountability. It ensures that behind every deletion request there is a traceable path showing the organization's diligence. Annual attestations or audits are another compliance anchor. Brokers must certify that they are meeting their obligations, and in some cases, independent audits may be required to validate these claims. This elevates accountability beyond self-reporting, ensuring that compliance is tested and verified. For example, an audit might examine whether suppression lists are functioning correctly to prevent repopulation of deleted profiles. Learners should see this as a quality control measure. Like safety inspections in other industries, audits ensure standards are not just theoretical but actively maintained. Penalties for non-compliance are structured to incentivize registration and timely response. Brokers that fail to register, ignore deletion requests, or perform inadequate deletions face significant fines. For example, a broker that continues to sell undeleted profiles after a confirmed request may be penalized for each violation. The cumulative impact can be severe, reflecting California's commitment to deterrence. Learners should see penalties as the enforcement engine. Without consequences, obligations risk being ignored. With them, compliance becomes the path of least resistance. The Act also prohibits re-identification or repopulation after confirmed deletion. This means brokers cannot simply erase one dataset while rebuilding the same profiles from alternate sources. For example, if a consumer requests deletion, the broker cannot later piece together their profile from public records or partner data. This prohibition closes a common loophole and ensures deletion is permanent. Learners should see this as California's insistence that privacy rights must have teeth. Deletion means truly removing information, not rebranding or reassembling it. Clear communication with consumers is required throughout the process. Brokers must provide accessible support channels, plain language explanations, and timely updates about request status. This prevents confusion and ensures rights are usable. For example, instead of vague messages like, "Your request is in process," brokers must confirm completion or explain limited exemptions. For learners, this reflects the user-centered nature of modern privacy law. Rights must be understandable and accessible to ordinary people, not buried under jargon. Finally, interoperability considerations ensure that brokers, upstream sources, and downstream clients can coordinate on deletion. Because data often flows through complex chains, the Act expects brokers to design systems that propagate deletion commands effectively. For example, when a broker deletes a profile, it must ensure suppression flags prevent the same profile from being reintroduced via another partner. Interoperability thus becomes both a technical and contractual challenge, requiring collaboration across the data ecosystem. Learners should understand this as the connective tissue of compliance. Deletion is only meaningful if it extends through the entire web of data sharing, not just within one company's walls. For more cyber-related content and books, please check out cyberauthor.me. Also, there are other prepcasts on cybersecurity and more at baremetalcyber.com. The Delete Act is designed to coordinate with existing CCPA and CPRA consumer rights, particularly the rights of access, deletion, and opt-out. Instead of creating a parallel structure, the Act provides a centralized pathway that complements and extends existing mechanisms. For example, a consumer who submits a CCPA deletion request to a retailer must be accommodated by that retailer alone, while a Delete Act request ensures their data is simultaneously erased across all registered brokers. This coordination reduces fragmentation and consumer fatigue. Learners should see this as an example of layered privacy law. Baseline rights in one statute are amplified by sector-specific or activity-specific obligations in another, with the Delete Act creating special accountability for brokers who otherwise operate outside the consumer's direct awareness. Contractual flowdowns ensure that deletion obligations extend beyond the broker to its data sources and recipients. A broker sourcing records from marketing partners or selling profiles to advertisers must incorporate contractual terms that require deletion propagation. For instance, if a consumer requests deletion, the broker cannot simply purge its database. It must also instruct its upstream suppliers to suppress the data and its downstream buyers to remove associated profiles. This flow-down design prevents the reappearance of deleted information in the data ecosystem. Learners should view this as California's recognition of interconnected data economies. Compliance cannot be confined to one actor but must be woven through the supply chain. Technical patterns for deletion under the Act include suppression, tombstoning, and irreversible erasure. Suppression involves flagging records so they cannot be re-added. Tombstoning replaces identifiers with placeholders to prevent reactivation, and irreversible deletion removes all traces from active and backup systems. Each method addresses different challenges in data management. For example, tombstoning prevents accidental re-import of a consumer's information from partner feeds. Irreversible deletion ensures long-term privacy, particularly for sensitive categories. Learners should see these techniques as part of the practical toolkit of privacy engineering. The law sets the expectation of durable deletion, and technical teams must implement it in a way that resists accidental or intentional reversal. Because deletion systems are attractive targets for abuse, the Delete Act emphasizes risk controls for identity fraud and adversarial requests. Brokers must protect against replay attacks, where malicious actors reuse legitimate request tokens, and against fraudulent submissions designed to wipe someone else's records. This means implementing safeguards like multi-factor authentication, secure session tokens, and anomaly detection. For example, if a flood of suspicious requests originates from a single IP address, the broker must investigate rather than blindly execute. Learners should see this as a reminder that privacy rights and security defenses must work in tandem. Deletion is powerful, so it must be tightly controlled to ensure it benefits only the rightful consumer. Edge cases in brokered datasets present unique challenges. Household data must be handled carefully, as deletion requests may apply to collective records like shared device usage or family addresses. Minor data is especially sensitive, requiring verification of parental authority and careful application of exceptions to ensure children's safety. Protected class data, such as racial or religious inferences, must be purged with extra diligence to avoid unlawful profiling. For instance, if a broker has inferred household income or political affiliation, those derived attributes must be deleted along with the underlying identifiers. Learners should understand that deletion is not one-size-fits-all. The Act anticipates complexities and demands thoughtful solutions tailored to different types of data. Transparency extends to retention schedules and deletion coverage by category. Brokers must disclose how long different types of data are kept and confirm that deletions apply not only to raw identifiers but also to derived profiles. For example, if browsing history is deleted, the behavioral segments created from that history, such as sports enthusiast or new parent, must also be erased. Disclosure provides consumers with clarity about what deletion truly means. Learners should see this as essential for trust. Retention and deletion policies are not just internal guardrails but promises to the public, demonstrating that brokers are serious about erasing the digital footprints of those who request it. Data mapping and provenance tracking form the backbone of deletion compliance. Brokers must know where data came from, where it is stored, and where it was sent in order to execute deletion effectively. Without accurate mapping, records can remain hidden in secondary systems or reappear from partner feeds. Provenance also allows brokers to demonstrate that data sources are reputable and deletion commands are respected. For example, if a consumer's email is deleted, provenance records must show whether that email was also included in external datasets and how those copies were addressed. Learners should see mapping as a visibility exercise. One cannot delete what one cannot find, so robust inventories are indispensable. Vendors supporting request routing and registry tools must also be governed by oversight mechanisms. The Delete Act anticipates that brokers may use third-party platforms to manage large volumes of consumer requests, so contracts and audits must ensure these platforms process requests securely and accurately. For example, a request routing vendor must provide assurances that deletion commands are not delayed, lost, or misapplied. Vendor oversight here mirrors broader privacy compliance. Outsourcing execution does not outsource responsibility. Learners should view this as part of the larger principle that accountability follows the data, no matter how many layers of partners are involved. Transparency reporting is required to show aggregate volumes of deletion requests, reasons for denials, and remediation efforts. By publishing these metrics, brokers demonstrate accountability to regulators and the public. For example, a broker may report that 90% of requests were fulfilled within statutory timelines, while 10% were delayed due to verification issues. Transparency reporting helps regulators spot systemic problems and gives consumers confidence that the centralized system is working. Learners should see this as a feedback loop. Data about requests becomes data about compliance, reinforcing trust through openness. Consumer education is another duty under the Act. Brokers and authorities must provide plain language materials explaining how the process works, what timelines to expect, and what exceptions may apply. For example, a guide may clarify that certain financial records cannot be deleted immediately due to legal retention obligations, but will be erased once those obligations expire. Education empowers consumers to exercise rights effectively and reduces confusion that could erode trust. Learners should recognize education as a crucial part of modern privacy frameworks. Rights must be accompanied by clear guidance to make them usable in practice. Cross-state developments are also shaping broker regulation. Vermont, Oregon, and other jurisdictions have broker registration laws, though not all provide centralized deletion. The Delete Act may serve as a template for national harmonization, either through voluntary adoption by companies or future federal legislation. For example, brokers may find it simpler to honor California-style requests nationwide rather than creating state-specific workflows. Learners should understand this as California's recurring role. By setting ambitious standards, it nudges other states and businesses toward broader harmonization, reducing fragmentation in privacy compliance. The Act's business impact is significant, particularly for analytics, marketing, and credit-adjacent use cases. Deletion reduces the size of available datasets, challenging models that depend on large-scale consumer profiles. For example, a broker supplying data to credit card marketers may see segments shrink as consumers exercise deletion rights. While this creates operational friction, it also encourages innovation in privacy-friendly analytics and contextual advertising. Learners should view this not only as a compliance challenge, but also as a strategic shift. The data economy must adapt to prioritize rights alongside business goals. Governance dashboards are an emerging best practice for brokers. These dashboards provide executives with real-time visibility into request volumes, processing times, denials, and risk exposures. For example, a dashboard might flag that a high percentage of requests are delayed in one system, prompting leadership intervention. Dashboards turn compliance into an enterprise metric, ensuring privacy is not buried in back-office processes but tracked like financial or safety performance. Learners should see dashboards as a way to operationalize accountability, making abstract obligations concrete and measurable. Finally, continuous improvement cycles ensure the Delete Act's obligations remain effective over time. Brokers must refine their processes to reduce residual data, strengthen deletion verification, and adapt to new risks. For example, if audits reveal that deletion commands are not consistently propagating to backups, processes must be improved to close that gap. Continuous improvement reflects the broader compliance culture. Privacy is not a one-time project, but an ongoing commitment. Learners should see this as the essence of resilient systems that learn, adapt, and get stronger over time, ensuring that deletion remains durable, defensible, and consumer-centric. Thanks for tuning in to the Bare Metal Cyber Prepcast, your trusted source for cybersecurity news and insights. Remember to subscribe at baremetalcyber.com so you never miss an update. And visit cyberauthor.me for best-selling cybersecurity books that equip you with expert knowledge. Until next time, stay secure and stay vigilant.